Many of the great debates in U.S. politics have revolved around the power of the national government versus the power of the states. What happens when they clash? What if the Congress passes legislation for which there is no explicit textual basis in the Constitution? Should the Constitution be read narrowly to exclude that power, or should it be read broadly to allow for it? This question was presented in the 1819 Supreme Court case of McCulloch versus Maryland. At issue was the question of whether Congress had the power to incorporate, that is, create, a federal bank. Congress did so in 1816, and Maryland taxed the operations of the Baltimore branch of the bank. The bank refused to pay the tax, and the Maryland law was upheld by the Maryland courts. The U.S. appealed to the Supreme Court of the United States. Politically, there were two views on the power of Congress to create a federal bank. One view was held by people referred to as nationalizers, and they argued that a federal bank was crucial for the growth of the nation and the federal government, and therefore the Constitution should be read broadly to allow for this power. The other group, known as the states' writers, said this power was an anathema, that a federal bank would interfere with state power over the economy, and that therefore the Constitution should be read narrowly not to allow for this power. Now, there was some history on which both sides could call. At the Constitutional Convention, James Madison had proposed giving the Congress the power to grant charters of incorporation, and that would allow for the chartering of a bank. The convention rejected this, so Madison assumed Congress had no such power. But the Constitution did include the so-called Necessary and Proper Clause in Article I, Section 8, and it gives Congress the power, and I'm quoting here, to make all the laws which shall be necessary and proper for carrying into execution the foregoing powers. End of quote. The foregoing powers referred to the powers Article I, Section 8 gave to the Congress. However, there was little debate on what this meant at the convention, and its meaning was unclear. The first Congress passed a bill creating a federal bank in 1791, and President George Washington sought opinions from his cabinet on its constitutionality, and they ended up as the arguments in McCulloch nearly 30 years later. On the one side was the Secretary of State, Thomas Jefferson. He said the bank was unconstitutional, and he gave 4 reasons. First, he said it was not an enumerated power, meaning it was not in the Constitution. Second, he pointed out that such a power was rejected at the Constitutional Convention. Third, he said that to imply such a power was an inadmissible reading of the Constitution. It would render the enumerated powers, that is to say, the list of powers Congress had, meaningless. And fourth, he said, the word necessary in the Necessary and Proper Clause meant indispensable, not merely convenient. Opposing him was the Secretary of the Treasury, Alexander Hamilton. And Hamilton argued that Congress had the power to charter a bank for 3 reasons. First, he said that the Congress had resultant and implied powers, that is, powers that resulted from those granted in the Constitution and implied by the Necessary and Proper Clause. Second, he said the Necessary and Proper Clause ought to be read broadly to give Congress power, not to limit it. And third, he offered a means-ends test. What he said is this: if the ends of congressional legislation were constitutional, and if the means were related to them and not themselves unconstitutional, then they should be allowed. President Washington signed the bill and the bank was created. It expired under the terms of the legislation. However, a second bank was enacted in 1816. It was followed in 1818 by a depression and a financial panic, and the bank started calling in many of its loans. And as you can imagine, this upset a lot of people. And indeed, several states, particularly in the South and the West, took action. For example, Indiana and Illinois simply prohibited banks not chartered by themselves from operating in their territories. And 6 states, including Ohio and Maryland, taxed the operations of what they called foreign, meaning out-of-state banks. And therefore, Maryland taxed the operations of the Baltimore branch of the federal bank. Now, it turns out James McCulloch was the cashier of the bank, which meant that he was the chief local agent for the U.S. government, and the Baltimore Bank was the most active branch of the federal bank. In 1819, a congressional investigating committee found that the bank was poorly managed. To put it more bluntly, McCulloch was systematically looting the bank. And he was removed from office just a few months after the decision, and half of the branch office directors were forced out. The bank had lost over $1 million back in 1819. So when the case reached the Supreme Court, emotions were running high and things looked pretty bad for the bank. There was a general dislike of it due to the hard times, and the Baltimore Bank had this very poor reputation. In addition, 5 of the 7 members of the Supreme Court had been appointed by Republican presidents Thomas Jefferson and James Madison and would presumably be opposed to the bank. And Maryland had great lawyers arguing for it. Luther Martin, for example, was one of them. He had been an active dissident in the Constitutional Convention where he had cried out against the chains being forged for his country. His country was the state of Maryland. Now it all seemed to be coming true. There were 9 days of argument at the Supreme Court, and the opinion was delivered only 3 days after that argument concluded.